Good afternoon, everyone. I bid you all a warm welcome in today's sixth session of this FDP. Today's topic of discussion is mediation post-COVID scenario. It is my honor indeed to welcome the special guest of today, Shri Manvendra Singh Ji Bhati, Advocate, Rajasthan High Court, Jodhpur. He is a highly qualified personality who holds more than 7 years of experience. He has participated in domestic as well as international commercial arbitrations and attended the proceedings before the Honorable High Court. He is a panel lawyer, Rajasthan Subordinate Ministerial Staff Selection Board, Jodhpur Development Board, RICO. He appeared and assisted Honorable Court in various public interest litigations and relating to legal mining and saving community lands. I may fall short of my words to count his achievements here on this platform, but I would specifically take in account his expertise in mediation post-COVID scenario. It is my indeed honor to welcome you, sir, on this online platform. Over to you, sir. Manvendra, sir.
Thank you, sir. Thank you very much. Firstly, I'll extend my heartiest congratulations and appreciation to the team of Pacific University and School of Law for organizing a 7-day extensive interactive program for the faculty.
Sir,
I'm sure when I heard...
Sir, your voice is very low, sir. Please.
Yes, sir.
Yes,
I'll just...
Yes, sir, it's fine now.
Now you're getting my voice, Dr. Abrar?
Yes, sir.
You're getting my voice, Dr. Abrar?
Getting, sir, getting.
Yes. Thank you. So it is actually my honor to be a part of this faculty development program. Initially, when I was given this proposal, I was very... I must say, I thought and I believe that it would be a very challenging experience because since I'll be interacting with the faculty who itself has an extensive experience under their belt. So I thought, why not take this opportunity? And especially when we are talking about mediation. So I thought, why not give it a chance and interact with the faculty? Maybe after this conference of 7-8 days, I'm sure positive result will be reflected in our curriculums and the law students, which will, I'm sure, must take benefit out of the faculty who are enriched with this experience. So with your permission, shall I start?
Yes, sir.
I was given this topic of mediation post-COVID. Before we start on this topic, I am sure that these past 2 years have been very, very challenging for each and every one, whether it be professionally or personally. But I'm assured that everyone with a very positive attitude has moved forward, whether it be the first lockdown or second lockdown. And even in these challenging times, I'm sure people have managed their way out. And when we see this positive light, I believe technology has helped a lot. Whether it be a person, any citizen who is sitting in a far-flung area, or whether it be in academic purposes, or whether we see day-to-day court workings. I remember when this first lockdown was imposed, initially our honorable courts and the courts, it was deemed that we have to work. Though it was a challenging experience to work in COVID, there were lack of uncertainties. This technology aspect in every field, I believe, has helped a lot. I still remember in our initial days of lockdowns, Honorable Court used to give us a WhatsApp call or a Google Duo or a Google Meet call, wherein the lawyers would appear and plead in their respective cases. So that was basically an arrangement for a week or two. Thereafter, the Honorable Court shifted on Jitsi Meet app or Window, WebEx or Zoom. So I believe our latest vernacular, Zoom, Google Meet, video conferencing is the new norm. So when these systems and these technological advancements are new norms, these advancements are also an integral part of our day-to-day legal system. And when this topic, I must, my sincere thanks and regards to the team, which has specifically chosen this topic, mediation post-COVID. So what I will share, I have divided mediation in 2-3 different branches. Firstly, what I'll cover is the concept of mediation. Second is, when we speak of concept of mediation, mediation is again divided into 2-3 different branches. That would be the parties, the stakeholders, the mediators, the present scenario in India, regulatory authorities, bodies, guidelines, rules, regulations, and judgments. Thereafter, how mediation was before independence, after independence, what is the legal framework in the present scenario. So basically the concept and essentials of mediation. The second portion would be a small portions of the past of mediation, what mediation was in Indian society. Secondly, would be evolution in modern India, how mediation, or maybe we must say alternative dispute resolution has come up in the recent years, maybe specifically in the past 20-25 years, and the present scenario in the last. When we speak about mediation, mediation is an integral part of alternative dispute resolution. And when we speak about alternative dispute resolution, it is deemed knowledge and it is agreed that we in Indian society always believed in interaction from one people to another, another people to another, from one culture to another culture. So there was always a dialogue. So when there is a dialogue between two people, two communities per se, there are always chances of conflicts. There are always chances to grow. So when there is a chance of conflict, at the same time, through that very same dialogue, we have all the chances to resolve those dispute or conflicts by dialogues. So when we see recently this Afghanistan fiasco is happening, one government is being overpowered or overthrown by extra forces. We name it as Taliban or terrorist organization, XYZ names. So there is always a statement or a common word in media which we find. They say dialogue between the two parties, or the interaction between, or formal talks between the two parties. So when we say two parties, we as humans have evolved day by day. What 500 years back our dispute resolution mechanism were, what they were during Mughal periods, what they were during British or colonial periods, what they were post-independence, and most importantly, what they are right now in the past 20 years on the onset of industrial revolution, they have changed. So, sir, post-COVID situation, in my scenario, things have drastically changed. And why not mediation? Why not litigation? Why not, for that matter, education? Imparting or taking of that education. It must change, and it should change in a very, very better and efficient manner for all the stakeholders concerned. So I would start with alternative dispute resolution. And alternative dispute resolution, when we speak about ADR, it can be different mechanisms. One mechanism, as we all know, these days in commercial matters, we use words as arbitration, conciliation, and mediation. For that, previous 1996, we had different acts governing arbitration or enforcement awards, Arbitration Act of 1958, and then there was a Consolidated Act of Arbitration and Conciliation Act 1996 that was majority based on unilateral law passed by the the model laws passed by the United Nations. So in arbitration, we gave 3 different modes of dispute resolutions. One was arbitration. The second mode was conciliation, and that also of mediation. So before we start, ADR is basically when we speak about alternative dispute resolution, they are non-adversarial in nature. So when we enter in these mechanisms, they are not adversarial. So for example, when we file a suit, or when we file a litigation before the learned honorable courts or learned courts below, before the civil courts, some disputes per se are adversarial in nature. That is, if we win, if we file a suit, if we file a writ petition, if we file a proceeding before a tribunal, there is always a scene of winning and losing. So one party contests a litigation to win, the other party, after a decision or judgment is rendered, loses. So in ADR is basically a non-adversarial in nature. So the process or the outcome is basically all the stakeholders is kind of a win-win situation. It's more of an informal process. When we appear before the honorable courts, either it be before High Court, Honorable Apex Court, or in learned civil courts, it's more formal because we have a procedure laid down, like we say Civil Procedure Code, Criminal Procedure Code. So there are procedures how to go before the honorable trial courts or the honorable High Court or Supreme Court. There cannot be any deviation when we approach the civil courts. But when we say ADR gives, mind you, though it's an informal proceeding, but there is no casual approach. So there's a very fine, or maybe it's a very separated field. It's an informal process where all the parties are given a conducive environment, but at the same time, though there's no procedure stricto sensu, but you have to maintain a discipline or sincerity for that proceedings. So in a broad view, it is an informal process. It's less expensive and more expeditious, goes without saying. If done in proper environment under the able guidance of like arbitration institutes or experienced arbitrators. Now in India, we also have mediation centers coming up. We have court annex mediation. So if done in a proper environment and if a proper conducive environment is given to both the conducive parties, I believe there are chances of settlement of disputes in a very, very amicable and a respectable manner. ADR would not only be less expensive, because when we speak about judiciary or dispute resolution, or for any scheme to be implemented in a nation which has a population of 1.3 billion people, we have to see that all the citizens have a stake in this democracy. So when we talk about these citizens come from all walk of life. So, sir, just imagine, I was very lucky and fortunate that I went to Government Law College, Bombay. So I learned this thing from city of Bombay, sir. They were very exhaustive, inclusive people. So you will have this 100-story building in the most the poshest colony or the area available, and at the very same time, adjoining to that building, you will just find a common man living in a small juggi. So it was very strange. I'm sure in cities like Udaipur, Jodhpur, we have a kind of seclusions. These are VIP or posh areas, like we say in Lutyens, Delhi, and then so in city of Bombay, it was like there's this 100-floor building, and then there's this juggi, a common man living with dignity. So when we talk about citizens of India, we have people coming from all walk of life, whether they are rich, whether they are poor, whether they are coming from city life, whether they are coming from village life, whether they are coming from northeast or west or south or north. So our laws are framed which says that every person should be treated equally before the law. When we read Constitution, Article 21(14) speaks about equality before law and equal treatment of law. So mediation or maybe ADR is one platform where both the parties can sit equally and under able guidance can resolve their disputes. So ADR in broad way would reduce hostility. In ADR, there would be a sense of control because most of the time they are time bound. So it is never ending proceedings, like grandfather prefers a suit for partition, or maybe there's a suit for declaration of an adjoining land, the same suit because of unavoidable reasons or because of some circumstances, the son of that person contests the suits, or maybe the legal representatives. So in alternative dispute resolution mechanism, there's no hostility between the parties per se. There would be a sense of control between both the parties. You would either of the parties would accept the outcome because it would be a win-win situation, because there's always a clash between what you want, what they want. Mediation or in ADR would find a common ground, what actually would be a win-win situation to both the parties. So it will resolve the dispute in a more peaceful manner. ADR would be, as I said, would be less time consuming. There would be confidentiality. Just imagine there are family disputes. It goes without saying, though no one wants that. After, like we see in family courts, there are family courts established. No one would want their family linen to be washed in front of the eyes of the public. Everyone would want that if a husband and wife are at an end where they want to very respectably part their ways. I believe, or any family dispute, I believe everyone would be with me on this point. They want to settle their dispute in a very private and a confidential manner, because nobody wants that their private disputes would be thrown out in the public. Generally, these unfortunate events do happen. So confidentiality is one major portion of mediation in India, or maybe everywhere, because there. So if we have a husband and a wife want to live together, like we say this restitution of conjugal rights under Section 9, or they prefer a divorce petition under Section 13, or there's a mutual divorce petition under Section 13B. So if there's a mediation, which do obviously the family court provides a mediation, an opportunity to amicably settle the dispute. Even the honorable courts, when the matters of such nitty-gritties or sins are being there placed before the court, the honorable court always make this a point, that force the parties in a very free and fair manner should be given this conducive environment to iron out their differences. So that is a must, I believe. So instead of pushing a party directly to the court, I will also share the areas in which we have the laws in India have made considerable growth in providing parties before contesting a dispute to approach a mediation or a platform or conciliation center. It was I was fortunate enough to participate in one proceeding. So before the NCLT came in, so winding up petitions were filed before the Honorable High Courts. So there was this dispute between two. One was a mining conglomerate, and there was this one company who was supplying coal to that mining conglomerate to fire their coal engines to generate electricity, and plus to be used in their furnaces. So there were some disputes between both the parties. X party saying that we demand Y amount because of these shortcomings in the contract. There was a breach of contract. That's why we will not pay you that Z amount. Whereas A party was saying that there's this B disputed amount, which is undisputed amount. Hence, you have to pay it at come what may. So since that payment was never made, a winding up note petition was filed before the Honorable Court. So after around 7-8 months of continuous hearings before the Honorable Court, it was amicably decided that why not we prefer, or we send this. It was a proposal obviously given before the Honorable Courts, that why not this winding up petition may be forwarded to a trained mediator who would iron out the differences between both the parties. So I still remember the name. It was Shriji Shipping versus Hindustan Zinc of Limited, Hindustan Zinc of India. So that NCLT, so that winding up petition was forwarded to referred before the honorable, before the retired former judge, Mr. Justice Verma, for mediation. So you must feel it very. I even for me it was a very learning experiences, because that dispute which was being argued every alternate day or once in a week or twice in 2 months before the honorable court, both the parties were made to sit before the retired former judge, who acted as a mediator. Within a period of 1.5 months, they were able to sort out their differences, come to a precise defined settlement mechanism, that this much and the part would be paying much. And sir, they were able to resolve their differences, that commercial differences, within a period of 1.5 months. So mediation, if given in a very conducive environment, indeed parties can come to settlement. Mediation in India is very important. Goes without saying. Every day in newspaper we see, even past 2-3 days there was this discussion and observation by the Honorable Apex Court that there were appointments of honorable judges as Supreme Court judges, but tribunals are being not in function from past considerable time. So when there's a docket explosion and there's huge population who want their disputes or conflicts will be resolved in a very time bound manner and less expensive manner, they will have that faith restored in them. Because nowadays we have this debate going on that litigation sometimes takes n number of years, and in those years parties get tired out because of expenses maybe, or that dispute, the bone of contention no more exists, or that the issue has lost its steam. So mediation proceedings are a must, I believe. So therefore mediation would be voluntary. It would be a non-binding process, which should be and would be impartial, and a neutral mediator assist the party. So a neutral mediator would be there. Both the parties would present their case before the neutral mediator, and in a very impartial and a conducive manner, both the parties would settle their dispute. So, to be precise, mediator would not impose his own will or his order or judgment. He would act as a neutral third party to resolve the dispute. So more of a solution giver than of a order giver. So when we speak, since it is a faculty development program, and I am sure there would be learned professors participating in this conference, mediators indeed should have certain set of skills. Set of skills would mean that he should have a temperament for negotiation, because we don't want a mediator who would be forcing one party to enter into a contract or a settlement deed before, because the other party is pressurizing them. So that's why there's a great emphasis of neutral member. We see two parties contesting before civil court. One might be financially strong, the other party would not be that very strong. So in the eyes of mediator, as in the eyes of the learned civil courts or the honorable courts, both the parties are equal. So that character or temperament should be there in that mediator, because he should not succumb to the pressure of either of the parties. And that person should have that kind of flexibility, because sometimes mediation never happens at the fall of the hat. Sometimes you see there's a ray of hope, but both the parties would take time to come to that platform or agreed solution. So maybe those meetings could be spent at around alternate days or week or in a month. So basically you start on the 1st of September, then you listen to both the parties, you try your best to mellow down their differences, remove unnecessary quarrels, come to the core issue. And there should always be a creative aspect, because when there is creative aspect in the mediation proceeds, when there's a neutral mediator having a very good body language, having a very good temperament, which will assist both the parties to narrow down or to minimize their differences and come down to a common agreed solution, would be a very good mediator in my opinion. Thereafter, when we speak about mediation, there could be mediation in every form. So mediation starts from our own home, our own houses. Two brothers, two different families living in a common household, they can do a mediation. We say in our daily walk of life, community-based mediations. On a lighter way, if you live in a city, if you live in a village, you have mediation, you have panchayatis. So, like Lord Krishna, Bhagwan Krishna, he tried to mediate between Kauravas and Pandavas. He never took sides initially. If anybody would have read Rashmi Rati, so Rashmi Rati, Ramdhari Singh Dinkar says, or it is a part of our Mahabharata, that Lord Krishna goes to Kauravas and he offers mediation, because Kauravas and Pandavas are brothers. He gives them a conducive. He tries to give them a conducive environment, that why not you people agree to some common agreed platforms. एंड रश्मि रति कविता के अंदर 2 लाइन है कि न्याय दो, अगर न्याय हो उसमें भी तुम्हारी बाधा हो तो दे दो मुझे सिर्फ 5 गांव. सो वो पांडवों के लिए भगवान कृष्ण सिर्फ 5 गांव मांगते हैं. So if you are not agreeing to all this settlement of your kingdom, so give me 5 gaon, give me 5 villages, because these are 5 Pandavas, give them that. But at least do some justice. So that mediation process fails. So we should not lose heart that a mediation process fails. But then there should be an honest intention when you approach both the parties. It is a sine qua non, because the temperament of that mediator would go a long way. So if the mediator has that temperament, it would help both the parties. So it can be a community-based mediation, which happens on and off, though they are less informal, because family members, community people do come and participate in. It can be a private mediation between 2 parties in the presence of a third person. It can be a court-annexed mediation, like in family courts, guardian matters pertaining to Guardianship and Wards Act. So before you approach the court, ऑनरेबल कोर्ट डायरेक्ट्स यू फॉर मीडिएशन. हस्बैंड और वाइफ के बीच में कोई डिस्प्यूट है तो प्लीज आप इनको मीडिएशन सेंटर भेज दीजिए. और मीडिएशन सेंटर के अंदर एक न्यूट्रल मीडिएटर होगा, हस्बैंड और वाइफ के बीच में जो डिस्प्यूट्स होते हैं उनको सेटल कराएगा. और मे बी व्हेन इट रिलेट्स टू कस्टडी, or maybe when it relates to alimony, there is always this always the parties are at loggerhead. So for example, in Industrial Dispute Act, if there's a dispute between employer and employee, there's a system, there's a mechanism under the Industrial Dispute Act. Force the parties will be sent for conciliation. On the failure of conciliation under Section 10, a reference would be framed, and that reference would be forwarded to the labor court, honorable learned labor court. So these mechanisms are needed, because when we are speaking about employer-employee relationship, it would be deemed that employee would be in a higher pedestal, because employee is working before the employer. There comes the role of mediation. There comes that aspect of temperament of mediator. There comes independence of mediator. That's why word neutral third party. So that neutral third party would equally see employee and employer on a same light. He would not, or she would not, form a distinction between both the parties. Sir, ये employer है, ये employee है. मेरे को employer को favor करना है. So that's why it should be more or less, it should be a neutral person who acts as a mediator. And there are pre-institution mediation. So if anyone after this conference would go for Bangalore Mediation, Arbitration Mediation International Center, that center in Bengaluru is doing very great. They have their own rules. So we have institutional arbitrations. We have arbitration association in India also. Like you have very famous institutional arbitration in Singapore. I was in one of my international commercial arbitration. I assisted my senior. That was proceedings before London Arbitration Center. The award was from London. So you have arbitration center in America, that is AAA. You have SIAC in Singapore. You have arbitration center in London. So in Indian concept, we have one center in Delhi. We have one center in Bangalore. They are doing very good. They have their own rules, own centers, trained mediators. In fact, Honorable Apex Court, or it was way back in the year 2002, 2003, at the request of the Honorable Chief Justice of India, though then, trained mediators were invited from America, and Ahmedabad, by the center where that mediation training was imparted for the first time. Thereafter, now Honorable Supreme Court by the mediation committee, that name goes, it goes by the name, I will just share it. So it is a mediation training manual of India by Mediation and Conciliation Project Committee, Supreme Court. So they've issued this booklet. It's a wonderful booklet. The forwarded the forward of the magazine of the booklet is written, of the manual is written by Honorable Justice Swatantra Kumar. So that manual can be used for a common man, can be used for a mediator, can be used for a referral judge, can be used for litigants, can be used by lawyers. So it's an exhaustive and a comprehensive manual how to approach mediation. So in pre-institution mediation, though it's in a very nascent stage, because Arbitration Act was introduced way back in the year 96. Still in India, we have arbitrations, but arbitrations are more or less like when you prefer a section 11 application, that is section 11 of arbitration says that if there's an arbitration agreement in a contract between both the parties, and if there's any breach of contract, both the parties would forward their dispute before the arbitrator, and firstly that arbitrator would be mutually decided on if both the parties cannot mutually decide an arbitrator. Under section 11 of the Act of 1996, learned Honorable High Court appoints an arbitrator. There's a panel of arbitrators before the Honorable Court, depending on the gravity of the dispute. So in some cases, you have retired honorable judges acting as independent arbitrators, as sole arbitrators, or three arbitrator, or there are in where the money or where dispute is not running in couple of crores, or depending on the matters, and or obviously depending on the Honorable Court, a retired former district judge, or maybe Supreme Court judges, or honorable retired Supreme Court judges are these days being appointed as arbitrator. Recently, there was also this comment in the media, comment by the Honorable Court, and there's also a judgment which says that lawyers should also be appointed as arbitrators. Though there is a trend of appointing honorable judges as arbitrators, but then there is a judgment which says that even independent and experienced lawyers should also be appointed as arbitrators. So though arbitration was there in India in past 10 to 20 years, we have seen sea changes in arbitration, whether it be domestic or whether it be foreign seated arbitrations. Mediation is slowly gathering pace. That's why we don't have many institutions, but there are independent institutions and authorities and people who are imparting trainings for mediations and providing good offices for acting as mediators. Now we speak on the procedural aspect of mediation, or basically the components of mediation. What are the components of effective mediations? Components should be self-determination, there should be quality of process, there should be confidentiality, there should be neutrality, there should be voluntary, it should be voluntary. Both the parties should come with clean mind and clean heart, that there would be a settlement. Further, I would cut short because then there is further, it is basically mediation is mostly party centric. So indeed, you need a third party mediation, a third party mediator, but then overall mediation is party centric. If you go in history, everyone would remember that our former prime minister, because of some reasons, passed away in Tashkent. Tashkent at that stage was given as a good office to resolve by Russia, USSR, though then USSR, to India to resolve differences between India and Pakistan. So sometimes these independent authorities or independent offices do play a very, very important role. per se, both are democratic countries. They need not sovereign countries. No third country can interfere between disputes between India and Pakistan. But to give a conducive environment, a third party office at Tashkent was given to India and Pakistan to resolve their disputes. So that is what a mediator has to do. So for successful mediation, these are certain aspects which are required either from both the parties and from the mediators. Because if we are coming with some pre-inhibitions that come what may, I have to thresh the other party's ego or smash other party's ego, and I have to contest. Here, the role of mediator comes very important, because with his temperament, he is to give that conducive environment to both the parties, point out advantages, point out disadvantages, so that both the warring contesting parties feel it from their inner self that yes, mediation is a better and effective process. Then, as I've already covered this topic, that it is a private process, it is not open to the public, it is confidential in nature. Aim of mediation goes without saying, it is to amicably resolve the dispute. Dispute resolution should be done by some trained mediator. It should be done in the guardianship of a neutral third party. The role of mediator or mediation would be to arrive at a mid path. Both the parties should be given a chance, so that their side of the story, their side of the fact should be brought on record before there is a settlement process derived. So the characteristics of mediation broadly would be, it should be efficient, it should be effective, it should be speedy, it should be convenient, it should be less expensive. Because these days there are debates and there are observations by honorable court in various decisions that litigation should be at the doorstep and less expensive. Decentralization would mean, or justice at doorstep would mean, that a litigant should not travel thousands of kilometers to seek justice. That's why we have Gram Nyayalayas formed. Gram Nyayalayas would go to villages, solve those disputes which are there in Gram Nyayalaya Act, stipulated in that act, so that both the parties would not go to a revenue court or to a civil court, spend around 10, 15, 20 years contesting the dispute, then file an appeal. So the concept of Gram Nyayalayas or Lok Adalats for that matter, or mediation center. So just as it's an open discussion, and correct me if I'm wrong, if there's a trained mediator at every district headquarter and two contesting parties who have a dispute, say for example a common piece of land. So if you go as per the revenue acts to settle the dispute, you'll have to approach the office of subdivisional office, file a petition there. If that is not in your favor, or in either of the parties' favor, you'll approach Revenue Appellate Authority. From Revenue Appellate Authority, you'll go to Ajmer Revenue Board, and Ajmer Revenue Board, you'll prefer that award before the Honorable High Court single bench, so on and so forth. So if there's a conducive environment given at every district headquarter by a trained mediator, which though indeed is done by Gram Nyayalayas, and sometimes these revenue officers also conduct these kind of Nyayalayas, which is a positive step forward to reduce pendency of the court. I believe these disputes, this docket explosion before the learned courts will reduce drastically. So that's why mediation would be effective and efficient, provided done in a very professional manner. It should be done in a very informal manner, but at the same time, there should be respect in regard to that proceeding. When we say about role of mediator should facilitate communication. It should promote understanding between the parties, assist parties in identifying interest. That's very important, sir. To me, when you raise a dispute, there can be 10, 20 different grounds we must not contest on each and every ground, because when you contest tooth and nail on such grounds or disputes and issues, sometimes frivolous, sometimes fired by ego clashes, there would be no common ground of settlement. So in such circumstances, mediator should assist parties in finalizing core issues. So instead of raising 20 disputes, you have 5 broad disputes which needs to be settled. Rest of the things would fall in place automatically when you agree at a settlement. So further, there should be creativity agreed, and both the parties should have that freedom to enter into an settlement agreement or walk away decently and approach the appropriate forum, whether it be SDM court, tribunals, or civil court. So that kind of freedom is also a must. That's why that neutral third party should not succumb to the pressure of either of the parties. Then there, I've prepared some notes. Then regarding qualities of mediator, I believe impartial is a must. Like it goes without saying, and I need not even lay great emphasis on word impartiality, because for any presiding officer, impartiality, you cannot go without impartiality. It should be he or she should be, or that institute of mediator should be independent. You should not be mentally or emotionally detached with that dispute, and should have that objectivity or that clear thought process in his or her mind. You should have that clear thought process that these are broad views. This is the contour which I have to draw between the parties. The dispute should not be beyond this. So he should not be only a neutral person, he should also act as a guide in mediation proceedings. So not only should be a facilitator, but also as an evaluator, because mediation proceedings never happen in one sitting. It is very good if it happens in one sitting, but then these sittings can go on for 3, 4, 5 sittings. He should be non-judgmental. He should not propose solution at the first instance, but yes, he should bring down the disputes to limited areas instead of spanning those disputes to 100 different minor issues. He should assist the parties come what may, or maybe we can the mediator can act as a proposal carrier. So if X party has a proposal which can be a common ground for the Y party, so in a very smart and a very non-judgmental manner, mediator can be a proposal carrier from one party to another party. So on that proposal, that Y party can give its comments, and those comments can again be transferred to that X party, and a common ground can be derived. This is how generally the mediation happens. Very interesting fact about mediation proceedings is, firstly, the parties at one point of time can walk away, because if you compare mediation with arbitration agreement is binding on both the parties. So there's an honorable retired judge or one arbitrator who is appointed by mutual consent of the parties. Your arbitration proceedings are binding, though they are expeditious in nature. Arbitration Act provides that arbitration proceedings should conclude within a period of 1 year from the appointment of arbitrator. But then those are proceedings where sometimes CPC applies. You have evidences. Parties need to file affidavit. On those affidavit, cross-examination happens. There are pleadings. So mediation, such things are not necessary. Maybe you can give your submissions in 1 page, 2 page, 3 page. The dispute involved, a party can submit their own proposal because of which dispute has arisen. And on basis of that, there can be a written agreement signed by the parties. And these, mind you, these written agreements are treated as decree. So when Lok Adalats or these mediations, they submit their recommendations before the honorable court, and honorable court, if sees that both the parties have agreed to mediation and they've agreed to some settlement of terms, they are as good as decrees. Decrees of the honorable court, they have to be effective and made to effected and to be executed in letter and spirit as their decree of the honorable courts. So it would be signed. Interesting part of mediation is in the event of failure, where parties cannot settle their disputes in mediation, the report of that learned mediator will only say not settled. There's a judgment of Motiram, in which there's observation by the honorable court that mediator need not say mediation could not succeed because of the role of X or Y. कि सर एक पार्टी ने मीडिएशन के लिए सपोर्ट करा, दूसरी पार्टी ने मीडिएशन के लिए सपोर्ट नहीं करा, मैंने ऐसा ऑब्जर्वेशन करके एक रिपोर्ट भेज दी. So to save the honorable courts, or to save that's why non-judgmental is one of the prerequisite for a mediation proceedings. So when there's a failure of mediation proceedings, the report will only say not settled, and that's it. You can go before the honorable court or respective appropriate forum, and you can contest your pending litigation in that manner. Sometimes one of the added advantage of mediation is you are free to agree to any form of mediation technique to arrive at an amicable settlement. And for that matter, you can forego your liabilities and entitlements. So to arrive at a common consensus between two warring families, or between two commercial entities, maybe you're legally entitled to XYZ things, but for settlement of that dispute, you might forego your legal rights or entitlements just to settle that dispute. So this is the beauty of these mediation proceedings if done. So as the saying goes, it's better to bend a little than to break. मतलब आप थोड़े से झुक जाओगे तो ज्यादा फायदा रहेगा, otherwise आप टूट जाओगे. So it should not be done. For that matter, any legal proceeding, in my opinion, should never be an ego tussle. These days, because of unwarranted reasons, litigations have become more of a ego proceedings than to settle their disputes. So it would give unnecessary load on the courts as well as on other appropriate forums. I would further, I suppose I have some time, I'll just cover up some aspects of ADR in India. Dr. Abrar, I'm sure I must have some time.
Yes, sir. You are. Please continue, sir.
I just want to guide or take this conference on the legal aspects, how the law in India has evolved. The biggest or the benchmark out of the law, how the law has evolved in India, there was this amendment in section 89 of CPC, Civil Procedure Code, which envisages mediation as a mode of settlement, which envisages alternative dispute resolution as one of the mode of settlements. So when we say alternative dispute resolution, courts, there's one more judgment which says what kind of matters, which I'll even, for the participants, I'll even share, which says what kind of matters. Like generally when we speak of ADR, it goes without saying acts relating moral turpitude, or for example, an offense under section 302 cannot be settled by mediation. So maybe these heinous offenses or heinous acts or crimes or disputes cannot be settled. So that judgment speaks of issues which can be settled by way of ADR. So two commercial dispute between both the parties, obviously it can be settled. Family disputes, either between husband and wife, custodial disputes, industrial disputes. So there are n number of possibilities where ADR can be used and can be used as an effective mode of settlement of dispute. So section 89 of CPC provides with ADR, And this section 89 was amended, and this mode of settlement was given on the basis and recommendations of Law Commission and on the basis of Malimat Committee. Then there is Order 10 Rule 1A, 1B, and 1C, which says that courts shall direct the parties to opt for either modes of settlement in section 89. So therefore, this ADR proceedings are even recognized thoroughly by the legislature and the courts. Therefore, they have that kind of legal sanctity. When we say mediation, and these days, or community, business community is debating a lot on ease of doing business. Sir, mediation can be used in one more aspect. We see a lot of discussions regarding Indian context in terms of foreign investment. There's always some reports or articles written by legal luminaries or persons with expertise in that field that in India, litigation is never ending and time consuming, which would delay the project. Mediation is, in fact, as I said, I have experienced that mediation in my own case, wherein Honorable Justice Verma mediated between two warring parties. Foreign investors would feel very happy when there's conducive environment for mediation between two contesting parties when one of the parties is a foreign investor, because these modes reduce the time of litigation. Indeed, there would be conflict when two parties are working together, but when the chances are that dispute would be settled within a time frame of 1 month, 2 months, 6 months, or a year, in party would come and invest in India. So, changing time of commercialization, mediation is very important. Order 23 of CPC again deals with compromise suit and declares that settlement will be recorded and a decree will be passed. And as I have already stated beforehand, that these decrees are equally on same footing as decree of the Honorable Court. Then Order 27 and 32A suggests that the court will assist parties to arrive at settlement in every suit involving dispute with government or dispute relating to family matters, respectively. Thereafter, arbitration and conciliation of this act governs ADR, wherein section 74 mandates that settlement agreement shall have same effect as if an arbitral award is enforceable like decree. Section 30 of Arbitration Act is another important legislature. Section 30 stipulates that if the arbitrator feels that both the parties can amicably settle the dispute, even arbitrator can provide or can send the parties for mediation. Just see how wonderful these proceedings are and effective, that even when an arbitration proceeding is under process, the parties can opt for mediation, settle their dispute, and submit their agreed settlement terms before the arbitrator, and learned arbitrator can pass their award. Therefore, first and foremost, in my opinion, there should be a will to settle. If there is no will to settle, I suppose, whether it be ADR or whether it be learned courts, it would be difficult to settle any dispute. If you see these days, many courts, many government agencies have started mediation between contractors. If you go to PWD or NHI, there is a must of there's these days arbitration is must before you go to litigation or before you go to mediation. Over and above, subject to correction, I remember there's this saying in Buddhism that it's one word of peace is better than 1,000 hollow words. Or this Sanskrit quote goes, "Santosham paramam sukham." So instead of contesting tooth and nail, if conducive environment is given by the parties, given to the parties, I suppose litigation can settle in a very conducive environment, in a very non-hostile manner. There is, I'll just not take much time. There is provisions under Hindu Marriage Act Special Marriage Act under family law, so basically to settle disputes amicably. In Legal Service Authorities Act 1987, again, Lok Adalats provide for mediation and settlements. Vikram Bakshi is the name of judgment, wherein Honorable Court has stipulated conditions what kind of disputes can be settled. Then there are certain differences between mediation and arbitration. As I've already stated, mediation is again non-informal. There is no procedure. Arbitration is more formal. There is procedure. There is this sense of adjudication, or it is more of directive, because when the learned arbitrator passes an award, it is in favor of one party, or it is partially in favor of one party and against another party. So there's no procedure in mediation per se. It's less formal or maybe informal. It might not be directive in nature, because both the parties are agreeing to settle the dispute. So mediator acts as as facilitator rather than adjudicator. Then there is Lok Adalat and mediation. Lok Adalat primarily deals with recovery and claims. Mediation can deal with all types of settlements. Mediation can be opted by parties. Lok Adalat, the honorable courts can send the matter to Lok Adalats. Lok Adalat, there is a presiding officer. Mediator, you don't have a presiding officer. It is not in presiding nature, rather as a facilitator. One important aspect, and I need not go again and again on that aspect, but then as per data which I've collected on the judicial data grid, there is around pendency of civil cases to the tune of 1 crore 4 lakh and 44,000 cases at high courts, at civil courts, and there is around pendency of 41 lakh 68,000 matters pending before respective high courts. So we as lawyers, or maybe an officer of court, or maybe the participant of this conference being academic in nature, our emphasis should be providing a conducive environment wherein we facilitate two warring parties to settle or come to mutual beneficial terms, rather than sending them to contest litigation. So first endeavor should be, or this is what my seniors taught me, that first endeavor should be try to resolve the matter, acting as an impartial third person. Don't force them to contest litigation unnecessarily where disputes or the gravity is very less. Unnecessarily guiding a party to litigation for your own sake would, in the end or in longer term, our court and our judiciary would be in pressure. Because day in, day out, sir, in our profession, we hear word called as frivolous litigation. Why? Just to harass that other party, we'll misuse our legal system. Just to harass someone. So our endeavor should be primarily to settle the disputes in a very, very amicable manner. More or less, I've covered, yes, the dispute. I am open for question and answer, or if anyone wishes any clarification, I would be very happy to help.
Okay, we are enabling the chat. Yes, sir. Sir, we are enabling the chat for the participants. They can post their questions in the chat box. Certainly, if someone feels like talking here, we can enable voice also. Just let us know in the comments. We again request all the participants, if they want to ask any question, they are okay. So we have got a question from Dr. Chakravarti. Please refer, sir.
So what remedy lies when a litigant is defrauded to sign an agreement to favor a powerful party? Sir, these are basically, then again, you're speaking about 420, section 420 of IPC, because these are questions of defrauding one party to another. So if you read judgment of Vikas Khanna, so honorable courts have, and plus when you read Legal Service Authorities Act, there are provisions which say such type of matters can be settled by way of mediation. But when there's cheating, when there's defrauding one party, when one party has been coaxed to entrust a property to another, when those disputes are criminal in nature, I believe because I am sure you'll file an FIR before the police station rather than approaching a mediator, because this is all not only an offense against one party, but these are offenses against the state. So when offenses against our state, I believe mediation would not be a feasible option. So when there's a dispute between two private parties, per se, mediation would be a beneficial option, because you have specifically used word as defrauded to sign an agreement to favor a powerful party. So when there's an aspect of defrauding one party, or there's a concept of there's an aspect of cheating, I believe it would be section 420 of IPC would be attractive, because of that defrauding property has been entrusted to another party. If I made myself clear, sir.
That is the criminal recourse, sir. But what will happen to the order passed by the Lok Adalat if it happens in Lok Adalat based on that agreement?
Sir, generally Lok Adalats, the orders of Lok Adalats are not appealable because they are final, because they are mutually agreed upon. Generally orders of Lok Adalat, but then it depends on case to case, sir.
Yes, sir. That is why I'm asking. I'm asking. Actually, I have encountered with a real life case where one party was a single mother.
Okay.
So she signed a particular document which was written in English, about which she has no understanding.
I am sure she must not be averse with English. Therefore,
yes. So and thereafter.
Sir.
Yes. So,
sir, you have to challenge that order of Lok Adalat, sir, with all great respect. But then those pleadings are a must, sir, because the order passed by Lok Adalat is in open court, sir. There's nothing in closed courts. So it's difficult to satisfy the appellate court, sir.
In that agreement, sir, that lady has put a thumb impression, and
Agreed,
that LTA has not been witnessed by anyone, that somebody is certifying that LTA of that person. But based on that, an award has been passed. So sometimes what I have experienced, sometimes even Lok Adalat is in hurry or is in need of passing some award, because they have to show something that this amount of cases they have disposed of. So this kind of pressure sometimes compels the judges to overlook this kind of mistake, which I have personally experienced. And
so that's more of a procedural aspect. And yes. I can share my experiences, at least in terms of proceedings before Lok Adalat. What I feel, because since I don't know the clear facts of the case, what I feel it must have happened is one party must have drafted that settlement agreement, signed by the other party, and placed it before the Lok Adalat. So unfortunately, Lok Adalat must not have had that kind of opportunity to ask the litigant, because when both the parties have placed their respective signature or thumb impression, So there would be there must be that impression given to the Lok Adalat that both the parties have agreed to settlement, because both the parties are to be present before the Lok Adalat. So had that lady, unfortunately, because that lady was not aware with English language and the content of the document, so I believe that order can be challenged.
Yes, so 226. So under
Sir,
226.
Sir.
I hope you got the answer, Dr. Chakravarti. It was a beautiful explanation of that concept. Welcome, sir. So please unmute yourself. बोलिए सर. Okay, now I invite Mr. Surendra Singh Bhati to offer vote of thanks to the esteemed speaker. Over to you, sir.
Thank you, sir. Good afternoon to all. On behalf of Pacific School of Law, Pahir University, I offer heartfelt vote of thanks to our keynote speaker and today's guest, Mr. Manavendra Singh Ji Bhati, Advocate Rajasthan High Court, and who spent his busiest schedule for our occasion. And I would like to
Pleasure
also
in mine, sir.
thank you, sir.
Pleasure is
And
mine.
I would
Thank
like
you.
to also especially thank you for rescheduling your session on our request. It was really, we are very grateful for that. And I would like to quote one of your sentences, which I have found really interesting and impressive. When you said that ADR in today's matter, it's mediation, is informal proceeding, but there is no casual approach. It is very interesting quotation, which I found really informative. And summing up your session, I would say that what you said, that proper environment is required and honest intentions are required for mediation to grow in India, if I'm not wrong. So
Certainly, sir.
with that, today we had the opportunity to hear your thoughts on this very relevant topic, and definitely will be encouraged in our future endeavors also. Thank you so much again, sir, and thank you to all the participants also.
Thank you very much, sir. Thank you very much. You people are doing a wonderful job. Thank you.
Thank you, sir. We'd like to hear you in future also, sir.
Thank you. Pleasure is all mine. Thank you.
Okay, sir. Thank you. Thank you for coming, everyone.
Thank you, sir.